When a California corporation is dissolved or suspended, it loses all legal rights and protections. Your business can't operate, collect payments, or even defend itself in court. The good news is that reinstatement is possible, and today we're covering exactly how to bring your California corporation back to good standing. A suspended corporation in California essentially ceases to exist legally. You cannot conduct business activities, collect payments for goods or services, participate in court proceedings, or even keep your doors open. These severe restrictions make reinstatement crucial for business continuity. Reinstating your corporation involves several key steps. First, you need to determine why your business was dissolved. This could be due to unpaid taxes, missed filings, or other compliance issues. Contact the California Secretary of State or Franchise Tax Board to identify the specific cause. Next, resolve any outstanding tax liabilities. This means contacting the California Franchise Tax Board, submitting all delinquent tax returns, and paying what you owe. This step is often the most time-consuming part of the process. Then file the required forms based on the reason for suspension. If the Secretary of State suspended your corporation, you'll need to submit a statement of information. For Franchise Tax Board suspensions, you'll file an application for Certificate of Reviver. You'll also need to pay reinstatement fees, which vary depending on how long your corporation has been dissolved and the reason for suspension. Some businesses may qualify for fee waivers under certain circumstances. Once reinstated, request a certificate of status to confirm your good standing. Then you can resume normal business operations, ensuring you remain compliant with all regulations moving forward. Failing to reinstate a dissolved corporation carries serious consequences. Business owners may be held personally liable for debts and lawsuits without the corporation's liability protection. Your business cannot legally enter new contracts or enforce existing ones. Unpaid taxes and penalties continue to accumulate, increasing your financial burden. Your business name might become available for others to register if you wait too long, and your reputation with clients, vendors, and financial institutions will likely suffer. For foreign corporations operating in California, the reinstatement process has additional requirements. You'll need to determine which agency initiated the forfeiture, either the Secretary of State or the Franchise Tax Board, as each has different procedures. If the Secretary of State forfeited your foreign corporation, you'll need to complete a new statement of information and provide documentation showing your corporation is compliant in its original state of formation. You may also need to amend your articles of incorporation. For Franchise Tax Board forfeitures, contact them directly to determine the necessary actions to reactivate your good standing. This process can take 3 to 6 months if handled from another state, so working with a local professional can significantly expedite matters. Nonprofit corporations face special considerations for reinstatement. Starting January 1, 2016, California implemented AB 557, creating a streamlined process for dissolving inactive nonprofits. However, to reinstate, nonprofits must reestablish tax-exempt status if it was revoked, settle all past obligations, and potentially file new articles of incorporation. They must also notify the California Attorney General before reinstatement. The reinstatement timeline typically ranges from a few weeks to several months, depending on the complexity of your situation and how quickly you submit required documents and fees. While legal assistance isn't mandatory, working with an attorney can help ensure compliance and expedite the process, especially with complex tax or legal issues. Reinstating your California corporation is essential for restoring legal protections and resuming normal business operations. By understanding the cause of dissolution, filing the appropriate paperwork, paying outstanding obligations, and obtaining a certificate of reviver, you can return your business to good standing and avoid the serious consequences of remaining dissolved.